right. Well, it is my distinct pleasure to introduce the moderator for this panel is navigating the regulatory landscape, which we know is not an easy one. Eddie L. Pounds, E. Pounds, is chair of the TPAD Foundation, and I'm really excited to have Eddie Pounds moderate this panel of attorneys, and what they are discussing today does not count as legal advice. Does that work?
Especially from Manir.
Especially from Manir. You give all the legal advice you want. All right, take it away, Eddie. Thank you.
All right. Are you doing introductions or? Okay, I am. Okay, so, all right, everybody, can you hear me first of all? I have a big voice, but all right, good. Before we get started, because I hate that we have to come after lunch, so I know everybody's got, a little bit of sleepiness. So why don't you do me a favor? Everybody just take a minute and stand up. Just stand up. And now put your arms above your head. Okay, just stretch real good. Yep, all right, good. Yep, all right, now sit down. All right, there we go. All right, let's get it started. So I'm Eddie Pounds. I am an attorney. I am a lobbyist. I'm a partner at Perry White Ross and Jacobson. We're based in Annapolis. I like to tell people we have beachfront property because my office sits right across from the State House. So I look out of my office window and I can see where most of the sausage gets made. I've been practicing law for about 18 years, lobbying about, 14 of those years. Lobbying is just another term for a fancy way of saying government relations. We help clients navigate governmental agencies or regulations. I've been in the cannabis space since about 2016. I represent multi-state operators, social equity licensees, and applicants. Many of you know the Cannabis Administration and the Office of Social Equity might be conducting a lottery round next week. So I'm hoping that all of my clients get that lucky ticket. I'm hoping that you all, many of you, might be applicants. I hope you all do well also. So I'm going to do my best to just pass the mic along for other introductions. It's pretty hot up here, but I'm going to try to step back a little bit.
Yeah.
If I take my jacket off, they might go a little crazy. So no, just kidding. The guys are going to get jealous. All right, so we're going to start with Aaron Gorman Kirk. Very enthusiastic and lively personality. Aaron, why don't you share with the audience who you are and what you do in the cannabis space?
Thanks so much. I run a couple different companies, one of which is Cannabis Government Strategies, and I try to help people, particularly social equity individuals, from application to finalization and everything in between, from real estate to funding to employment, HR, and we also draft legislation. So if you're in any state or have a desire, you can always, shoot us something. And I do this very much, a lot of it pro bono. So if you have something and no one is helping you, I'm happy to do so.
Thank you. I'm Manir Hawk. I'm the VP at Curate. Back in 2015, we were running around preaching why security compliance is important in the cannabis space. Excuse my language, but nobody gave a shit then. Until it became a thing important. So that's what we do. We do IT and security in the cannabis space.
Hi there. I am John Wax. I am a lawyer with the firm of Offit Kerman, 300 attorneys from New York to South Carolina and now California. I do regulatory work and corporate work and intellectual property. I am the chair of our cannabis practice. We do a number of things for cannabis companies. We represent growers, processors, dispensaries, testing companies, landlords, lenders, software companies. We help with applications. We help with business transactions. We help with compliance. So when operators get in trouble, we help them hopefully get out of trouble. We do networking. We sponsor a lot of events like this and education as well. We put on a lot of webinars, and we also blog through LinkedIn. If you're not LinkedIn with me, please do so. We're trying to update people on developments in our program. Thanks.
So I think he read from my script. My name is Mike McQueenie. I'm a partner at the law firm of Foley Hoag. About 400 attorneys spread across 4 or 5 offices: Boston, New York City, DC, Denver, and Paris. Cannabis attorney, it's 100% of my practice. I'm on the regulatory side. We have other colleagues throughout our firm who work on the corporate side, tax side, real estate side. It's a interdisciplinary approach. I'm also a professor of cannabis law and policy at New York Law School. For what I do in my day-to-day, it's, again, working with clients who are looking to get licensed, both in competitive application writing states and in lottery states. In lottery states, I always say when they win the lottery, it's all due to me. When they lose, it's the fault of the state. But yeah, really enjoy what I do. Work with clients here in Maryland as well on the medical side and the adult use side, and looking forward to speaking with everyone today.
This is truly an all-star panel. I've had the pleasure of working with Foley Hoag and also Jonathan's firm. And let me just tell you, we play very well together and get wins and successes for our clients. So let's give them a warm round of applause, please. All right, so let's jump right in. We're going to start with the impact of rescheduling. I think Christina Johnson might have mentioned that earlier. And we're going to talk a little bit of tax law, 280E, okay? So in the ever-evolving landscape of cannabis legalization, there are 2 terms often come up in discussions: rescheduling and descheduling. And sometimes people interchange them, right? They might sound complex, but they're vital to comprehend if you're interested in the changing legal status of cannabis. That prompts me to pose a few questions to the panel related to the impact of rescheduling and the IRS provision known as 280E. First, Jonathan, let's unpack what 280E is and its impact on cannabis businesses.
We talked a little bit about 280E in an earlier session. 280E is Section 280E of the Internal Revenue Code, and it basically says that the IRS's official position is, even though you are engaged in an illegal activity, we absolutely want all of your tax dollars. And not only do we want your tax dollars, we want a lot more than other businesses would have to pay. You can deduct from your business only cost of goods sold and nothing else. So the effective tax rate is at or above 70% as opposed to the normal rate. It is very difficult to operate profitably in the cannabis space when you're dealing with 280E. And 280E, I believe, applies to those businesses engaged in the sale of Schedule I substances or Schedule II substances, so that if it is rescheduled to Schedule III on the list of controlled substances, 280E would no longer be a problem. I would take some issue with what Christina said earlier, where she believes that rescheduling will occur in the short term. I think that you have to be honest and say that if Joe Biden and others determine that cannabis should in fact be rescheduled, that doesn't take into consideration the fact that there will be litigation. There are others who believe that it should not be rescheduled, and therefore, like all lawsuits, the inevitable delay would be months or years before that rescheduling took effect. So all the companies that are thinking about following Trulieve and filing lawsuits to get back the money that they paid or are obligated to pay under the current system, don't count on getting that back this tax year.
Thank you. Let's, Michael.
Yeah, and by the way, just don't overlook the effect of 280E, right? And I think for most smaller business operators, it's also important to remember that 280E gets felt the most by dispensaries, right? So we mentioned here that cost of goods sold, as distinct from ordinary business deductions, are 2 different things, right? So most costs of goods sold can be deducted, and the more costs of goods sold are usually on the cultivation and processing side, right? So, I say 280E is one of those issues that's, egalitarian in its injustice, right? It hurts the big operators and small operators alike. But certainly as we see, social equity programs roll out, especially in the Northeast, New York, New Jersey, Connecticut, Maryland, most of those opportunities for social equity licenses are on the retail side, who are going to get crushed the most under 280E. And that's just a major point to flag, because again, the biggest impact of rescheduling is, right, Schedule 3 means no 280E, right? I think that's one of those things that we need to come through sooner rather than later, because it does have the biggest impact on the smallest operators.
I don't mind at all, Aaron.
I just want to throw in one quick thing. Maryland, Jersey, Massachusetts, and now Connecticut have done an in-state 280E workaround. And many legislators don't even know about it because they don't know about cannabis in the first place. But I went up to our General Law Committee rep last year, Mike D'Agostino. I said, listen, can you give me 10 seconds? And he said, what? And I said, 280E workaround, it's killing businesses. And he stopped and he said, I don't know what that is. So I gave him a 30-second, thank God, Tahir brought it up. You got to have that 30-second pithy thing. We got that passed within 4 months. He came to me yesterday or 2 days ago when we were testifying, and he said, thank God we beat some other states. Connecticut is literally, their motto is the land of steady habits. I don't know why you'd be proud of that, but they are a follower. They're not a leader. So if you're in a state or you're working in a state, Kentucky's coming online, Ohio's got issues, they may be doing these in-state workarounds that are helpful. And the other thing I just wanted to bring up is, because there was a young lady here I was speaking to, there are these different impacts depending on where you are in the food chain. I have a client who's doing warehousing, transportation, packaging. He thinks his transportation and warehousing should be exempt from 280E, and we've asked the Attorney General of the United States, as well as the IRS, as well as our in-state Attorney General, is he trafficking? He's not touching the plant. He's, there's a lot of these really bizarre nuances that you have to learn. So Witham and Markham have not completely said that they think it's okay. And in fact, they're leaning away. Another entity said, yeah, we think you don't have to pay any tax. So I said, do we have an answer? You have to reserve all the cash you might be fined plus interest. So don't just pretend you're not paying 280E. Bank that money in a separate siloed account. If you get dinged, you'll be ready to go.
That's a great advice. That's great advice. I believe in audience participation just to keep you awake. So let me just ask, because sometimes lawyers and, non-lawyer, sometimes we talk in a manner that many people may not be able to connect with or doesn't resonate with you. So just by a show of hands, you all seem very intelligent, but I just want to know whether everyone knows the difference between descheduling and rescheduling, just by a show of hands. How many people know the difference? Okay, now how many people do not know the difference? Okay, it's a few. All right, I think somebody should kind of unpack that and talk about sort of like maybe the legal effect of rescheduling versus simply descheduling.
You want to go, Professor? You want me to take the first crack? Okay. So the Controlled Substances Act defines categories of controlled substances and has different levels of restriction for each category. So if we reschedule cannabis from Schedule 1, which is reserved for the most dangerous, most restricted controlled substances, such as ecstasy, down to Schedule 3, which means that it's treated like Tylenol with codeine, available for sale in pharmacies, there will be lesser restrictions. 280E goes away. There are some other problems that are solved, and there are some other problems that are created. Alternatively, with descheduling, we are acknowledging that cannabis doesn't belong on the schedule of controlled substances at all. And it is treated like, I assume, over-the-counter medicine or some other forms. Maybe it's treated like alcohol, but it's not on the list of restrictions for any of the 5 categories.
Right.
Sure, go ahead.
So, and absolutely right, by the way. I mean, and one of the things, and I'll just say from experience, I've dealt with this issue of federal versus state interpretation with Canadian auditors who have a completely different, conception of what cannabis legalization is. Where you talk about these differences, right? And at its core, notwithstanding the fact that we have all these cannabis businesses up and down the East Coast now, they're all federally illegal, right? There's bad things about that, like the effect of 280E, access to banking and loans and commercial lending and the like. Arguably, there's also some good things about that, right? Like setting up in-state social equity programs, right? Oftentimes that may be to the benefit of discrete communities within these individual states, right? So one of the things to bear in mind about federal legalization, there's great things about it, right? Removing 280E so that businesses are taxed just like any other businesses, and folks who run those businesses well can make money. There's other kind of unintended consequences of that, right? Let's think about the new cultivator in Maryland or New Jersey or New York, who is investing oftentimes $5 million, $10 million to build up these complicated in-state indoor cultivation facilities. Well, if it's descheduled and it's federally legal overnight, what happens? The borders come down, and all of a sudden, outdoor grown California cannabis comes in at a substantially lower price, which could threaten those eastern, northeastern indoor cultivators and the like, right? So there's just so much complexity and ripple effects that comes from federal legalization, right? So I think one of the things about Schedule 3 is theoretically it keeps up these borders, right? I mean, Schedule 3, one of the things that's on Schedule 3 is steroids. I can't just start selling steroids tomorrow just because it's on Schedule 3 as opposed to Schedule 1, right? So the unintended consequence of whatever happens at the federal legal level needs to build in this fact that there are all these entrepreneurs, especially in the Northeast, spending so much money dependent on these in-state infrastructures. We need to plan what that looks like and have a gradual impact of what these state borders mean, right? Because if we don't do that thoughtfully, it could have the unintended consequences of hurting a lot of these smaller businesses who are building with these in-state infrastructures in mind.
I agree.
May I add one thing in response? Because everyone assumes that rescheduling is happening and descheduling is not a possibility. There is a pending letter from many senators that is asking for descheduling and pointing out the policy arguments for why descheduling may make sense. Mike, to your point that if we move from Schedule 1 to Schedule 3, it's like steroids, and now maybe we need FDA approval for all cannabis products. I don't see that happening. Technically you need FDA approval for all the cannabis products now. That's not happening. With descheduling, we can help sort of rip the Band-Aid off for this inconsistency between federal and state laws and acknowledge that the criminal justice system penalizes people that have been accused of cannabis-related offenses, which are inappropriate and excessive. And if we go through the rescheduling model instead of the descheduling model, we're leaving those hypocrisies in place, and we're making it just take so much longer to fix the things that needs to be fixed from the criminal justice system and parity of laws that need to be corrected. So sort of an incrementalist approach versus a transformative approach.
So I just want
to... Before you start, we're going to get you in the game in a second. You got to ride the bench for a little bit. It's like, why in the hell am I up here with all these attorneys?
I'm not even going to get into it, but one other thing with the re, the D, the hey, the ledge, the legalization is we are bound by the UN Treaty of 1961. So there's a whole other international point of this. Nothing we have to talk about today, but it's kind of something interesting that I've been working on behind the scenes for 30 years. I'm like, UN, and there have been Shane Pennington, Matt Zorn, some smarter lawyers than I'll ever be, saying that, in fact, if we adhere to that contract, we are destroying our own communities, and no treaty asks us to impinge on our own people or circumvent our own human rights issues, which we in America feel that this is, I do, at least a human rights issue.
Thank you. Last question or discussion point on 280E. Jonathan actually shared an article with me that was published last week in the Baltimore Business Journal, and the headline was entitled, "Potential Law Changes Could Mean Big Tax Refunds for These Businesses." And in the article, there was a Baltimore-based accounting firm that urged companies to prepare for a change in federal law that could result in millions of dollars in tax refunds. And as a result, the firm advised cannabis firms in Maryland to file a protective claim with the IRS to preserve their eligibility for a tax refund based on the litigation that Jonathan mentioned earlier and pending changes to the federal law. Also in the article was a quote by none other than our fabulous Jackie Cohen-Roth, who was quoted saying she believes pressure from national lawmakers in the Department of Health and Human Services could lead to cannabis getting rescheduled by the end of the year. It's a complete contrast with my colleague Jonathan, but it's okay. But my question to you, panel, and again, Munir, we're going to get you in the game soon. My question to you, panel, is what are you advising your clients to do and why? You want to start at the end, Aaron?
I'm telling them be very damn careful and keep incredible records from before you even open your doors. I mean, if you're driving places, if you're doing anything, keep a record of everything. And then we'll see. I'm very wary because the government's the government, you know, the man's the man.
So there are some great software programs out there that can help operators track each task of each employee to separate between direct and indirect costs so that should you be audited, you have the backup documentation. It's not just a general philosophy. You can show that at this time, this employee did this skill, which was attributable to cost of goods sold, or it was not. Some people are considering filing protective claims, which may make sense. But the best advice actually is from you, Aaron, which is if you're going to take the position that you don't owe these taxes, don't spend that money, set it aside, document it. We heard at a prior panel that through predatory lending, the cost of borrowing money is somewhere between 20 and 25%. The interest rate from the IRS for non-payment of taxes is about 5%. You do the math. Back at the beginning of when I was getting involved with the program, people were overpaying their taxes to launder the money through the IRS to get them to serve as your unofficial bank. And now it's the opposite. People are underpaying their taxes because it's a lot cheaper to pay the interest and penalties in some cases than it is to pay these loan sharks the predatory loans that are being offered.
Yeah, I mean, what I would say is talk to your tax professionals. You know, and look, I mean, this hits on a really important point, and I know I've talked to some people here today about it. Is find the right professionals, right? You can find a professional to give you any opinion you want. It doesn't mean that it's right, so that's super important. The other big thing I would just say is whenever we get rescheduling or descheduling, and that effective tax rate goes from 70% to a lot lower, you know the other thing that's going to follow in the form of federal legislation, and that's going to be likely some form of federal excise tax that's added on top of it, right? Just bear that in mind that it's great to get change, but following change is going to be, hey, by the way, where's my money?
Thank you, Michael. Munir, let's pass the mic down to Munir. He's in. All right, let's talk, Munir, let's talk a little bit about data and how you keep all this data secure, and we'll touch on some compliance-related issues, and I think Aaron could probably jump in on that as well. So if you're a news junkie like me, many of you have seen recent news reports of these massive data breaches and cyber attacks where tons of personal information has been compromised. So just this year alone, and we're not even really 2 months in, there have been more than 29 billion known records breached so far in 4,645 publicly disclosed incidents. Cannabis dispensaries here in Maryland alone are probably handling thousands of records related to its medical and adult use patients and customers. Munir, what's going on in the industry? Are cannabis companies taking this potential threat seriously?
So I don't think they are. I don't think they're taking it seriously to the level that they should be. I also think it's a matter of time when you got that hacker sitting in his bedroom, turns his browser to cannabis, and he's done with Target and AT&T and all that stuff. So it will happen. Now, so as an IT security company, we work with a lot of applications and licensees, and a lot of the markets don't strictly identify what actual level of data security you need. So a lot of licensees, they call their internet provider, they get a modem, they get the cameras hooked up through a switch, like, cool, I got internet, I got a modem, the modem says it has this thing called a firewall, I'm good, right? Like, I'm HIPAA compliant, I'm like, everybody's safe. No, it's not the case. So imagine this, like, you guys go into a dispensary and they have a nice lounge and they give you access to their Wi-Fi, and then the person ringing up your product is using the same Wi-Fi that you were just checking Facebook and YouTube on, and then your staff is doing their homework on break on the same Wi-Fi. You have all this information just available for someone to take. So a proper secure network, and it doesn't have to be like Fort Knox, but there are elements that you need, and consulting in an IT team is crucial, because an IT team will put in a proper firewall. We'll make sure that every single item that turns off and on in your store and is talking up to internet is funneling traffic through this. So that's like the first step, and I see it amiss all the time.
So, but are there any repercussions, and this is open to you and the rest of the panelists, are there any repercussions if they don't take this seriously?
No. So, much like you're okay until you're not, right? Or you got by until you got caught. So when there is a breach or will be a breach, then there'll be repercussions. When that data leaks and, a bunch of people's names and information gets out there, there will be repercussions then. Right now, there's nothing. You're like, I'm transacting, it's working, it's fine.
Do my attorney friends agree with that assessment?
Go ahead. Yeah, I mean, so a couple things, right? So there's what I would call the general data protection rules, right? And a lot of states have statutes in place that say when certain HIPAA-related information or personally identifiable information is breached, is disclosed to the general public, there's certain reporting obligations that you have, and if you don't follow them, and this is state by state, certain attorney generals can come after you for damages. The other thing I'll say, and correct me if I'm wrong, I don't know that it's in the Maryland regulations, but it is in some other state regulations. There's states out there, New Jersey being an example, that says, as a matter of regulatory practice, you're not allowed to keep, on a default basis, consumers' information, right? So what's a common thing with dispensaries? You go in there, they swipe your card. Some dispensaries may keep that information. That's a regulatory violation to the state cannabis regulator, in addition to a potential threat on a data breach, right? So it's important to look at it up and down. What are the data protection requirements I have that any business in an individual state has, and what are the repercussions there? And in addition to that, does my cannabis regulator take a position about what information I can and can't keep? And if I can keep it, under what circumstances do I need to apprise the consumer of what I'm keeping, in what manner, on what basis, and the like, right? So it's kind of a multi-tiered approach.
So data breach rules vary from state to state. There is no national data breach remedy obligation. So for those of us who work with multi-state operators, it's helpful if they segregate all of the records state by state based on the consumer. It doesn't always work that way. And the rules state by state are changing several times a year. So California, I think, was the first state that wanted a European-style GDPR-esque set of rules and protections. New York followed, Connecticut followed, Illinois followed. Maryland has not yet followed, but it would not surprise me if Maryland passes its own version. So each operator should check with a privacy attorney on a regular basis to see what new obligations exist.
Anyone else?
Joyce? No. Just real quick, your point, Jonathan, is so well taken that states have different structures, but states change these things every year. And someone said earlier, you could be in the middle of being compliant and all of a sudden it changed. I'm right now, we're rewriting the bill in Connecticut, and there are incredible repercussions to some of these very small tweaks. So keeping the records, making sure you do segregate state by state because it could change. And then, my favorite saying, don't be defiant, just be compliant. Because you just can't fight the man.
Stay there.
You can't fight the man.
Let's unpack that a little bit. I'm glad you have the mic, because I want you to share a little bit more about how compliance actually plays into this.
So I know that there are people with far more compliance on their books, but what I am, raised a little Catholic girl, so I'm always like, do the right thing. Just make sure you're compliant. And in order to be compliant, you need to know what the regulations are. And you should read them yourselves, because your interpretation, and you can throw them through an AI and have it explained to you. But I would not rely on anyone else to tell me what my business has to do. There is a lot of wacky compliance stuff. Some of it's fairly easy. And then there's some that's overkill. Like I had a Jersey client who, a security guy wanted a card to get into the main grow rooms. All the grow rooms were down the hall, and then he charged them $4,000 for another card for each door. That's over compliance. You don't need to, that guy was just trying to make money. So you have to know the difference between, is this person helping you become compliant, or are they kind of padding your bill so that they can make more money? If you've got, if you've been in a cultivation, you're very segregated. You have to keep it clean, hazmat, the whole thing. So you don't really need a card for every door. Usually your head grower can have access to all those rooms. So again, it's just you have to make sure you're compliant, but do it in a sensible way, because capital's just so tight right now.
She hit on a really good point. So in my line, we review security plans every day, right? And one advice I have for operators, future operators, is always vet everyone that you're going to be working with. And you should also know the regulations, right? And, if you're working with a security company, ask them if they've worked in the state, ask them for referrals, because people will put in overkill. And like Aaron was saying, doors are expensive, like access control, and the money's going to come out of your pocket and into somebody else's, just by adding like 3, 4, 5 more doors. But the state a lot of times says that you just need to block off access to, say, this hallway that then will give you access to the other doors. So that's one door can solve that for you versus purchasing access control for every single door. So really doing your own research and knowing what you're doing, and not just relying on someone to do it for you, but also vetting the people that you're going to work with.
Aaron is right that you begin with a thorough read of the regulations. Manir is right that you don't stop by reading the regulations, that you have to talk to professionals. If you are looking for an opportunity to get involved in a business that has safe, easy, understandable, consistent regulatory rules, run away. Run away quickly from the cannabis industry, because there are ambiguities, there are inconsistencies, there are moving parts, and it does make sense to talk to people that have been involved with this issue, this regulatory issue, before in this state in the recent past. Someone who's handled it in California doesn't count as much. Someone who's dealt with it 8 years ago, it doesn't matter as much. Someone who's dealt with it in an analogous industry, it doesn't matter as much. Find people so that you can really find out what you can do and how you can do it, and if there are alternate strategies to success other than what is written directly into the regulations. Sometimes if you ask the regulator, can you do something? They have a very narrow definition. They will only look within the 4 corners of the regulations, and you need to understand, am I being overregulated? Is it an overly narrow interpretation? So I agree with both of you.
Yeah, I mean, all those points were extremely well said, and I'll more so just reiterate, right? I mean, I think the cornerstone thing is maybe trust but verify all your consultants. Do a little bit of a check on everybody. That point on everyone's trying to make a buck, I mean, that's not a sin, but it's something that you should check, right? So like, I have a client building a dispensary right now, and a question came up on backup power, right? And what was being recommended was extremely overkill, right? And we referenced back to the regulations, and we said, You know, we don't necessarily need the A++ system. The A system will be just as good. You raise a tremendous point, which is, bear in mind, the regulator is the one who interprets the rules. But when you're just asking an opinion, like informally, the regulator's not always right? They're going to take a most conservative approach. But in most of these modern jurisdictions, there's ambiguity in a lot of these provisions, right? So it's like, what meets the provision but doesn't necessarily break the bank, right? So again, across the board, whether it's the regulator, your contractor, at times your attorney, right? Trust but verify. Feel free to check people on things, you know, because in ever-evolving industries, especially brand new segments of the industry, you know, no one has a monopoly on right answers because most people are doing it for the first time in that market. And that point too of like, even if somebody's done something in your state, and like, I can't tell you how many times folks maybe have built a dispensary during the medical years when the rules tended to be the most stringent, and then try and apply those same standards on a build out in the adult use side of things, and people go way overkill on price, right? So again, constantly check your professionals, check yourself. This is an evolving industry. Feel free to always question what you know, check what you know, figure out whether or not you can get a most economical solution.
You know, you guys are sharing industry best practices, and I'm sure our audience here and those online are really appreciative. Some of the stuff might go into their SOPs. Are there, before we close this segment out, it's really important, and that's why I've spent as much time on this piece. But are there any other industry best practices out there that we could share? We don't normally share a lot of advice for free, but this time you're very fortunate. Any other industry best practices out there that companies should be taking advantage of or thinking about?
Compare notes, right? Like what again, like especially in a state like Maryland when there's so many different operators, maybe you've been told something from your direct report in the agency, someone else has been told something otherwise. I mean, there's a lot of trade associations and a lot of these groups that are formed exclusively for the purposes of trading on those best practices. Hey, you're doing it this way, that's certainly correct, but you ever think about doing it this way? It could be a shortcut to a lot of these problems, especially as the market evolves. Comparing notes, you know, competitors don't always compare notes, but in many instances, folks do it just because next time around they want to get that information from you as well.
So in the prior panels, we heard about all the different people that you need on your team. You're going to need 6 accountants and 3 attorneys and real estate professionals and marketing specialists. And you legitimately do need a lot of help in a lot of different areas. But I think it is helpful to manage a process if you're starting a cannabis business, like you're, you know, with a discipline of project management, identifying everything you need, and then match it against everything you can pay for, and figure out, you know, what other people will subsidize for you. So the Office of Social Equity is standing up a process by which the conditional licensees will be allowed to identify the services that they need, and there will be a list of preferred providers that may or may not have package deals. So figure out what you need, what you can pay for, and what other people will pay for on your behalf before you actually pull the trigger.
The comparing notes is huge. And also the associations. Those associations offer so much free information, and there's subgroups within that. There's rooms like this that meet up, talking to existing operators, you know, finding someone maybe that can mentor you. I think all those are things that you should be doing if you're not already be doing, and not just listen to the vendors that you've hired to tell you exactly what it is you should be doing. Shop them, shop all of them. That'd be my advice.
Add one quick thing.
Absolutely.
Couple things. If you're finding that something isn't working, get active in your legislature. Go to your reps. We've got a huge thing where they, in Connecticut, asks for vaults. The vaults have to be a number of feet thick. They weigh so much. Now you have to put your social equity businesses into diversity areas that are DIA areas that are created by a map. Well, there aren't any places to do it. So you really, really have to go back to your legislators, which we did this week, and said, can we expand? Can we change The vault. If you're on the 4th floor, can it weigh less? Can we use cages for beverages? We actually had a legislator say in Connecticut the other day, he didn't even know that they grew cannabis indoors. I thought it was all outdoors. I'm like, we have been doing this for 7 years and you have never read your own reg, bro. The other thing I want to echo is associations. So I probably shouldn't say this publicly, but what the hell? I worked with cannabis chambers of commerce in other states. When they started out, they were magnanimous and they were bringing everybody in from the legacy and the plugs to the politicians. They then decided they wanted to get the MSOs in there, so they started paying upwards of $25,000 to $50,000 for membership. My social equity candidates can't pay that. I do have general licensees who pay in the $10,000 range, and they all thought they were on the same page until recently when they went to testify and they weren't. So we started another organization called the Connecticut Cannabis Small Business Alliance. And our membership fees are like $25. You can give more if you want. But what's incredible about it is it embraces everything that I have spent my entire 40-year service in. Radical collaboration is key. I repeat that. Radical collaboration is key. This is an industry that very few people want to collaborate. You can save yourself millions of dollars and a lot of headaches, and you won't end up in that toilet in the jail cell that was spoken of earlier, you know? And I just think, excuse me, for example, our Connecticut Cannabis Small Business Alliance created a free AI database. If you wanted to testify, it went in and you could put in what you wanted to talk about and it created your testimony. We have put our whole RERACA, we've put the Maryland law through, and we do comparative analyses. So if there isn't one, organize one. Get yourselves a small business alliance where you're all going to share. I took the Maryland Cannabis Chamber of Commerce.org.I.everything because I didn't want to see, that's what I should probably not say out loud, I didn't want to see, and I believe in working with MSOs, there are definitely reasons to do so, but they don't necessarily have your best interests at heart. So I took the Maryland Chamber of Commerce because I want to see what everybody here wants to build. It's not for me to build. It's not for MSOs to build. Radical collaboration could get you a Chamber of Commerce that would get legislation taken care of and a lot of other good stuff. But a small organization cares more about you and will give you everything we do is free. Our tax guys are free. All of our work is, within limitation, free because we know people won't get it elsewhere. So I can't echo enough everything they've said, and also just get into those organizations, network, and if you don't see it, build it.
Great. Absolutely not. But
We do have a DMV chapter, District of Columbia, Maryland, and Virginia chapter of the Cannabis Chamber of Commerce. I host it through my office. We meet 8 times a year, 4 times online, 4 times offline. If you come, we build connective tissue. At this point, there are no membership dues, so it is an opportunity to get that free access to information that you need.
you guys are getting some good stuff here. So what we've been talking about is a good segue for this next topic, HIPAA, all right, which many of you might be familiar with. And when we're talking about privacy and securing data, it makes me think of patient privacy rights and HIPAA. I want to keep this with Aaron and Munir. Either of you, please share with our audience what HIPAA is and discuss whether there's any relevance to the cannabis industry. So in other words, does HIPAA apply to cannabis patients?
Yeah, so I could speak on behalf of what HIPAA is and how it applies. So, HIPAA is built of a lot of best practices, and ultimately what it is an umbrella for keeping patient data safe. A lot of that falls, like, so let me step back. Like, HIPAA's not going to come knocking on your door and ask, like, can I see your login to your computer and who has access and whatnot? When there's a breach, or if there's a breach, they're going to come knocking on your door, right? And then comes fines and whatnot. So it's an umbrella of all this ways of being compliant and protecting the information. So earlier when I was talking about building a secure network, having a conversation with your IT team and asking them, what are your HIPAA best practices? Do you even know what that means? and kind of go down that route. And what do you put into place and utilizing that? So for instance, if you guys were going to use our services, right? All of your workstations will have virus scans, right? All of your workstations will time out. If you were to get up from your desk and leave, every single person will have their own login. But then with that, there's a lot of education that has to come with that, like in the sense of what is phishing? Someone is telling you to pay an invoice. Did you hover over their email to see if it goes to the actual, email address that it's coming from and not some random weirdness, right? So there's a lot of training that goes involved too. So as a business owner, you do have to educate yourself in what HIPAA is, what it looks like, what the best practices are, and you do have to own a lot of that yourself. But asking, the vendors, your POS companies, your security company, your IT company, what do you guys do in relation to HIPAA, and how does that translate to my store?
Yeah, very, very, so true, so true. So I do write HIPAA contracts for providers that are even in the CBD space or that are doing holistic healthcare with like pharmacists, with a component where they used to work in a dispensary, they're now starting their own practice, and they refer you to the dispensary for your products. But they also have their own line of certain things inside. So I do a notice of privacy, I do a liability waiver, I do release forms, I have the patient acknowledge that, I make sure it's at least in 2 languages, and then I also give them an idea of how we use their information. And for my solo practitioners, I tell them not to keep too much information because they can get hacked. And then the really interesting thing I've found is whether or not you want to release your information to a third party. So if you're maybe an Alzheimer's patient or a veteran that doesn't get to go to the dispensaries, or there's a lot of different things. I try to show them how I'm going to use their information and whether or not I would give it to a third party. I let them opt in if they want to. And then I also say, who do you not want to get this information? Because I think that's also a really key part is, maybe it's your ex, maybe it's your work, maybe it's your children, whatever it is. I think it's important to say, this is who I don't want my information to get to, regardless of marital status or any other legal claim they say they have. Do not do it unless you talk to me first.
Thank you. All right, so we're going to switch up and talk about creditor rights and concerns and other issues. And our 2 subject matter experts are Jonathan and Michael for this segment. So John, Mike, either one of you, share with the audience what the CRA is, and talk to us a little bit about what the CRA has to say about creditors' rights issues.
CRA is the Cannabis Reform Act, which was made effective July 1st of 2023. We are operating under emergency regulations, temporary regulations, as it relates to standing up new rules for the expansion from the medical market in Maryland to the combined medical and adult use market. And as it relates to, I'm gonna nerd out a little bit. Subchapter 17 of the emergency regulations relates to creditor rights, and it says that the MCA is supposed to stand up a portal which will accept applications for individuals and companies to be designated either as secured parties or as receivers. There are some ambiguities and inconsistencies in the emergency regulations as it relates to creditor rights and potential receiverships, but the CRA does outline the things that are supposed to be included in an application to become designated as a secured creditor and an application to become a receiver. So where does that leave us? Right now, we are on the cusp, maybe next month, of issuing new conditional licenses. Almost all or all of these conditional licenses will need access to capital. And potential lenders are, to the most part, waiting on the sidelines to see whether and when the rules will become more clear with respect to rights of secured creditors and rights of receivers. In the spirit of full disclosure, I'm involved in some litigation relating to helping to clarify some of these issues. But I think that unless and until we get more clarity on the rights of secured creditors and until we have people that are properly designated as receivers, the ambiguity will be to the disadvantage of new market entrants.
One thing I would say is when the initial set of rules for a program includes explicitly receivership, that tells you a lot about the industry, right? That tells you that, you know, this really isn't, you know, what folks made it out to be 4 or 5 years ago, that this is an industry that mints millionaires. For everything that we talked about with Schedule I, you obviously can't get access to traditional banking and lines of credit. This is a federally illegal business, which means it is riskier, right? I mean, you touched on the point earlier that across markets you can see interest rates anywhere between 20 to 25%. On the one hand, that's high. On the other, it also tells you how folks who have money and are willing to lend into the space judge these businesses as a credit risk, right? This industry and these markets are a lot different from what they were even 6, 8 years ago, when a lot of these medical-only markets, there was 10, 12, 15 licenses, limited licenses. Those in credit terms are more bankable risks. The more licenses you have out there, the riskier the investment. And again, until there's a federal action that clarifies what lenders can do here, it's going to be this process of having to regulate what types of interest folks can do. I mean, and separate and apart from interest rates, one thing that a lot of states talk about in terms of lenders is the fact that, you know, oftentimes what lenders are doing are using the artifice of lending through secured transactions to really set themselves up to take over the business in 1 year, 2 years, 5 years, whatever it may be, right? So that's a big reason why Maryland has some preliminary rules on lending. We see other states who go a lot more in the weeds as to what lenders can and can't do for this reason, right? Like New Jersey will say you can't charge interest rates above 20%. You can't have, if you're taking a percentage of profits, it can't exceed what the license holder is taking. New York has some of the tightest rules where they basically say if you're taking over a certain threshold of economics, we're going to treat you as the same as an owner and apply those same restrictions on you, right? But I'm not saying one way or the other is right. I'm saying it's a gentle balance of how do we encourage and incentivize investment into what remains a risky business while still trying to control for, you know, the bad actors, so to speak, right? I don't know that one state has gotten this perfectly right. I mean, I know New York tried to roll out a program that says we're going to have a $200 million fund that we roll out for the help of social equity licenses. Guess how much money is in that fund currently, right? So there's no perfect model, and it's about a little bit of feeling in the darkness and saying what's the right mix, all else being equal.
Okay, we've got a few minutes left. This is our last question. Be sort of like a round robin, open for any of you. And let's talk about what the future holds for social equity licensees. So next week we'll have 179 provisional licensees coming into the market, right? Followed by another potential round in May, maybe. So there are a number of obstacles that will make it very, in my opinion, very difficult for these new operators to become operational, including a number of counties like here in Prince George's County that are trying to adopt further restrictive zoning ordinances to make it difficult for these new licensees to site a facility to conduct their business. With that being said, how easy or difficult will it be, in your opinions, for the new licensees to become operational and successful? And share with the group, the audience, any thoughts on helping them see a path forward.
I think the short answer is the award, if for those who are lucky enough to be selected, doesn't guarantee that you'll be open. Obviously, We talked about some of the local land use issues, right? I represented one of the first social equity retail licenses in New York State, and I was sharing this with Eddie earlier, where did everything right. The property was compliantly zoned, went through the local land use process, local land use entitlement process. They said everything looks great. You got to change these two things. Come back on May 2nd. You'll get your approval. What happened in the interim? On May 1st, that town changed the ordinance and it basically imposed a new setback requirement that took them out of the running, right? And it took a lot of legal posturing to get them back to the point where now they're back today where they should have been, 6 or 7 months ago. Look, oftentimes when the application gets awarded, then the hard work begins. And that's certainly true for Maryland. That starts with a lottery concept, right? You got to think about, am I bringing on new owners or investors and the like? Where am I going to locate my property? How does that work from a local land use entitlement process? Which vendors do I need to onboard? How am I going to staff up and hire up? It is a long process. And the only other thing I'll just say on top of that is, like, this is the epitome of cannabis, where you're like, oh, it's so much hard work to get the application in. Then you win it. Oh man, it's so much hard work to get this license open. Then you get the license open. Oh man, it's so hard to run a business. Then you get to that next phase. Oh, do I expand? The hard work never ends. The onboarding of the license only translates to running the license. It's all hard. I praise all entrepreneurs because everyone knows it's 24 hours a day.
So for those of you who get a conditional license soon, congratulations. As Mike said, that is, a ticket to a longer set of difficult issues. But I think that most people who win will, at least initially, have to grapple with 3 key issues: real estate, money, and team. As it relates to real estate, there are no shortcuts, but there are some shorter cuts. I know of some real estate companies that have built interactive heat maps to superimpose the state setback requirements on the local setback requirements, and figure out the zoning issues, so that if congratulations, you have the right to operate a dispensary in this county, but there are only 6 available properties and 8 available conditional licenses, you want to get access to that information sooner than others. As it relates to building out your team, if you can find someone who is already sort of on the inside and can act as your Sherpa to help you fill any empty seats at the table, that will be very helpful as well. Money is going to be difficult, and for the reasons that we talked about with creditor rights issues, you want to get started on that earlier rather than later to figure out what your choices are.
I agree with everything these two gentlemen have said. Working in a lot of different markets and working with a lot of different social equity groups, the hiring and the team have resulted in really big, long setbacks that I've seen. But also, when you obtain that license, there are a million things that you're going to be doing, right? So finding that Sherpa or hiring that Sherpa, someone that's overseeing everything above you and making sure that all the pieces are moving. I'm just speaking to things that I've seen that have prolonged by way too long, from operators, getting to generate revenue in other markets. So just making sure all those pieces are in place and checked.
Second that emotion, definitely. The problem when you're in a social equity situation is the division of your ownership. We have been complaining in this state, and this state, Maryland, has taken a lot of what Connecticut did wrong to do it right here. But if you can't apply equity principles to your business, that makes it hard to get money. In some states, if you own more than 5% or have a controlling role, you are a backer and you are an owner. I know Jersey got around a lot of things by doing MSAs, which were these management service agreements that basically said, I'm going to pay you next Tuesday for the hamburger I have today. So that got people into trouble too, right? And I protested in the Martin Luther King assassination. That's how damn old I am. I'm just bummed that we're not at I know, it's incredible how old I am, right? But it's a bummer that we're still fighting these same damn things that are the war on drugs that are disproportionately affecting people. They won't let us put our grows in places. You know, PG County says, you know, we're too highfalutin for herb. What are you kidding me? The stuff that just people make up to get in your way is a shame, and it's so much more impactful on social equity individuals. I have a client who's the great nephew of Rosa Parks. He did not need to go for a social equity license, but he thought it would be helpful to his community. He has since said, I wish I'd just gone to friends and family and done this, because now municipal pushback, we have all these other barriers because we're social equity, not general. And then there are social equity plans, and there's all these different things you have to do in your municipality to show that you're going to give back. It's harder when you are a 65-35 because that 35% is not going to give you everything you need, which is why to the earlier points Christina made and others, you have to have your own funds and you have to have a lot of savings.
Excellent. So that concludes our segment. Now we're going to turn it over to Jackie and let some audience members ask a few questions.
Is it? Yep. Okay. Give it up for these. Yeah. And who says lawyers are boring?
Good. We're good.
So we do have some questions. Let's start off right with the audience, and I have some online. And I appreciate who you are.
Hi, I'm Phil. Phil from Philly, and from Global Goes, my company. But one thing, I think it was Jonathan who mentioned that this is just a comment. For those of you, especially me, some of my relatives have questioned for the 6 years I've been in this space, like, what are you doing there? You can point out to them now that 12 senators have asked for cannabis not to be rescheduled, but descheduled. So that's an important point I think a lot of people miss. That was a really, really kind of groundbreaking communication. But anyway, the question, and probably Munir, maybe I'll start with you. You were talking about regulations, best practices, and I'm interested in what some of the others have to say, but do you advise clients to do basically self-audits, you know, like QA, periodic audits, and what has your experience been generally in clients being fined by state inspectors or others for not being compliant? Thank you.
Yeah. Got you, Rick.
I do. I think it is wise and very important for business owners, operators to, you know, take a hold of their business and understand what's happening. So the self audits, yes, and there's SOPs that you have, or you can high level pull out from your SOPs to create that audit. From working in almost every legal market, what I see, and you know, if there's any people that do audits in this room, I'm not pointing fingers, is right at the beginning, there are a lot of audits that happen. And then as the market grows, they become fewer and fewer and far between. So they, like, you know, New York right now, like we have clients that the OCM sends out like, hey, send me, 2 weeks ago footage from this time to this time on this camera in your Bolt, you know.
Thank you. All right. I have one from, anybody like to take that answer to that? Nope. Okay. Online. So getting, for those that are currently operating in the industry, this FinCEN rule, that would, you're shaking your head, Mike, would you address that? We have to file something, the current cannabis businesses by.
Yeah. So I think, is this on? Hello? So I think this is in reference to the Corporate Transparency Act, and it's
Yes.
It's not just, by the way, it's not just related to cannabis businesses. It's every business, every company that's been formed in the United States, right? So for companies that have been formed, I believe it's since the start of this year, January 1st, 2024, they need to file this Corporate Transparency Act filing. I think it's within 90 days after formation. For those that have been formed prior to 2024, they have to file that by the end of this year. It's essentially listing who your beneficial owners are. But again, it's a requirement for cannabis companies. It's a requirement for non-cannabis companies. So everyone in this room who has an LLC, bear in mind, you got to start reporting this information. there is certain exceptions to it for those that are interested. We have a kind of an omnibus white paper that we can share with folks, but it applies to everybody.
Great, thank you. I have a question right here from a colleague.
Hello, good afternoon. My name is Akila Witherspoon, and I am a student in the MCSD program, class of 2024. My question, I'm piggybacking off of the question about HIPAA, and considering that there's medical patients and now adult use. What do you think are the best practices, and are there any regulations that apply to adult use versus the medical use cannabis patients? And then do you think that it's just the best practice to set everybody up the same and have the same type of, I guess, protections that you would have when it comes to HIPAA, just for the adult use side as well?
I'm going to exhaust my knowledge of the subject in about 20 seconds and then hand it to Munir. But in most states, the most recent data that I saw was that in mixed-use jurisdictions where there is both a medical program and an adult use program, adult use sales account for 70 to 80% of overall sales. So whether or not it makes sense to have two systems, one for a HIPAA-protected set of data and one for non-HIPAA-protected, is not being done in Maryland right now, at least among my clients. That may change as the cost of compliance becomes higher, and it's possible that the number of medical patients goes lower. But right now, I think that most operators have a single database for both adult use and medical customers.
Yeah, and we have a couple POS vendors in the audience too, and they can also speak to that, after this panel. But I don't know what the retention is in Maryland, to be honest, because some markets make you dump the data like within 24 hours, but the operator does have to own this responsibility to make sure it's being done. And one of the best practices, so for instance, when you walk into a dispensary, you scan your ID and you get checked in, right? A lot of people leave those workstations on because they don't want to keep retyping in their password, or they forget their password because it's complicated. That is not a good practice. You turn around and that part-time security guy, whoever, like anybody can get into that. So that I would say is a very important best practice. But also, when you hire your IT team and your security team and your POS team, asking that question too, like, okay, so the state requires the data to be dumped in 24 hours. Let's just say that's the thing. Who is doing that? Knowing who is responsible to own that, and then you as operator spot checking it.
Okay, another question coming in from online, which goes to a conversation that we had on our Zoom meeting, was about diversity of licenses, and that there is a bill presently for a nursery license. Micah used a great expression, immaculate conception in this industry. Where did these plants come from? And so if you would explain what that nursery license is, and with that, and then a question also to the panel as part of that diversity of licenses, is there indeed an incubator license being awarded in this round?
I'm sorry, what was the tail?
So the first part of the question
on nurseries.
Yeah, is diversity of licenses. Yeah.
Yeah, so we talked a lot about metric earlier and this concept of seed to sale. In most states, a plant doesn't exist until it's about a foot, right? So there's this concept of immaculate conception where when any medical or adult use system starts up, where do the plants come from, right? So the nursery registration is essentially to be able to transfer some of these immature plants and clones, right? So I think a lot of this comes down to genetics, right? There are some folks who may be tremendous at growing cannabis genetics, but maybe they don't want to bring, that cannabis cultivation to max tier, right? So, what I like about this is thinking about kind of the diversification of the supply chain, right? Years ago, it used to be you had to be a vertically integrated operator. You did everything under one license. Then you start breaking up the licenses, cultivator, processor, dispensary. And now we have greater diversification even still with on-site consumption, with nurseries, right? There are some states coming up figuring out how do we break up the supply chain to also, in certain instances, make it more accessible. Connecticut's a great example of this, where I think there's 4 or so different types of processor licenses, which I like, right? Because not everyone wants to come in and do a little bit of everything. So you could come in at different capitalization levels. On the incubator side, goes to the same concept of, you know, what is often the most expensive part about operating certainly a cultivation or processing license? Finding the real estate, building out the infrastructure within those facilities. I mean, a cultivation facility can cost you $5 million plus, processing $1 million plus. These are large numbers. And if you can incentivize folks to incubate, to have a model where they have multiple licenses under one roof, you're allowing folks to participate in essentially maybe in a greater way than they would have with one individual license, while at the same time solving for some of these other issues in the industry, like access to capital, access to real estate, and how to actually stand up a license.
Great. Any one of the, oh, Michelle, you have something for me coming in?
I could tell about regarding and my processing like is like to what the state or the back on myself that work.
Ah, that's great question. So collaboration between licensees, is that legal?
There will be incubators established in Maryland, I believe is part of the current licensing round, and that will be available to, pardon me, second round, I apologize, second round. When it does exist, it will be available to house both micro growers and micro processors. I do think that there will be a delay. So once the incubators are licensed, it will be a period of time until it exists. I do think, like there is an incubator for physical space, the OSC is starting to establish a plan for an incubator of talent and advisors. So that is something that people will need as well. But, the diversity of licenses will enable the diversity of licensees as well. Not every team will have $30 million available and ready to build out state-of-the-art grow. So I think that the challenge we have as a state and as an industry is to create new opportunities for economic businesses, and also give them the opportunities and the resources to succeed and not set them up to fail by making something that's too complicated or too expensive to operate profitably.
All right, great. Thank you. So that wraps up our panel. We have time for a very short break. And I know, but yes, absolutely. So thank you, Eddie. Apologize. Aaron, Veneer, John, and Mike. Thank you so much, you guys. It was really fantastic. I know this panel, each one of these could go on all day long. So thank you so much. So quick break, grab something to eat, snack, and we're going to come back for the final roundtable of the day. And we are going to start sharp at 2.